Yes, absolutely. Appreciate you coming back on. We talked about the lead up to the case, and now we're going to talk a little bit about where things have come down after oral arguments. Obviously, they're not 100% predictive. What gets asked in oral arguments doesn't guarantee that a justice is going to go a certain way based on how they performed in the questioning. But you can take away some things, right? I mean, it's not a fruitless thing to look at these oral arguments. There's quite a lot in there that we can probably peel away. So let's start with just your brief itself. Last time you were on, you described your advice to the court in the amicus brief, which dealt with how this federal law is structured. This is the law that bars people who are under domestic violence restraining orders from owning guns, and it has two sections, two types of restraining orders that it can apply to. And you had said that the second part had an issue. Can you just explain that argument real quick? And then this got brought up in oral arguments. So
yes. How
did you think that went?
Sure. So Volume 18 of United States Code, Section 922, subsection G8C, Roman numeral 1, bans gun possession with up to a 15-year prison sentence for mere possession in the home by someone who's under a domestic violence restraining order when the judge who issued that order found that the person poses a credible threat to an intimate partner or child. Subsection C, Roman numeral 2, also imposes that same kind of ban without any judicial finding at all, according to the statute, and is simply an order that by its terms orders a person not to do violent things against the intimate partner or child.
Right. And your brief had an issue with that second part, right?
Exactly. We said that based on the Bruin methodology of, you look at the original meaning of the Second Amendment as that's elucidated by history and tradition, that there is a history and tradition both before and after the enactment of the Second Amendment of restricting arms rights for individuals who have been found to be dangerous on an individualized basis. And so C1, with the finding of a credible threat, is not an infringement of the Second Amendment in the sense that of targeting somebody like Rahimi to restrict his arms rights. Whereas C2, which doesn't require any finding of anything, we argued was a Second Amendment infringement. In the Solicitor General reply brief on behalf of the U.S. government, our amicus brief, that was the only amicus brief in opposition to the government side that the government replied to, and they said no, that's okay. The government can come up with, legislatures can identify categories of people, and they don't have to have a specific finding about an individual. And that, as you said, that did come up in oral argument initially by Justice Alito. Justice Gorsuch talked about it, and Elizabeth Prelogar, the U.S. Solicitor General who argued the case, obviously talked about it with them, and then even brought it up again in her rebuttal phase of oral argument.
Yeah, and it seemed like she kind of retreated from the brief in that her argument was in oral arguments was essentially that the judges who issue these orders basically are finding that somebody is likely to commit violence, even under that second paragraph, that they wouldn't issue a restraining order if they didn't have reason to believe that that the subject might actually commit violence against their partner.
Exactly. She made and this was not something that the U.S. government had argued in its briefing, but she did, as you say, retreat to a more defensible position in oral argument, which is that any court order under necessarily includes a implicit finding that the person who is ordered don't do that, that the judge must have found there's some likelihood that the person will do that, and that's why the order was issued. So even though the statute doesn't say you have to have any factual finding, she argues that there's an implicit factual finding if you drill down deep enough behind the statute.
Yeah. So she's kind of arguing that basically 1 and 2 are the same in practice, I guess, is kind of her.
Exactly.
Okay.
Which
yeah, go ahead.
Which is not really true, because there were 2 real solid amicus briefs from public defenders. I think one from the Alameda County Public Defenders and some others, and another from the National Association of Criminal Defense Lawyers, which, based on their own experience, say no, restraining orders are given out quite promiscuously in many jurisdictions. And this idealized version presented by the Solicitor General's office is just not true. That it's very common for judges to issue them with no real factual inquiry at all. That it's just safer for the judge professionally to issue restraining orders all around, and then because then if somebody does something bad, then the judge suffers a reputational problem that he or she didn't issue a restraining order beforehand. Even if there's very little or no risk that the person to whom the issue is ordered is actually any danger to anyone.
Right. And she rebutted that, I guess, with this. She brought up a legal principle that, to my understanding, and maybe you could give us a little better understanding of this, but essentially that the court has to assume that lower court judges are operating properly, that unless they have evidence to the contrary, right? That they're supposed to take in good faith these judges issuing these restraining orders. That sort of was her rebuttal. That was my understanding.
Yes, and that's exactly right. The problem with her argument is the amicus briefs we just talked about from the public defenders show that that's not the case. That there's plenty of evidence that judges are not always being factually thorough or having a good solid basis for issuing these kinds of orders.
Okay. And so I guess on your particular brief, which, was pretty narrowly focused on this dichotomy between these 2 aspects of the law. In fact, you said it could be fixed with a single word change, right? From
right.
Or to end. Where did you feel the judges were coming down on that? Or the justices? Do you think they're inclined to knock out that second clause?
I think it's always perilous to predict results based on oral arguments. I remember there was a administrative law gun case that the court heard back in the 90s, and one of my lawyer friends went to oral argument and said, "Oh, this was great. We're gonna win this one 9-0," and it did turn out to be a 9-0 case, but the other way. So it's I'd say what you can say for sure is the justices were engaged in the issue and thinking about it seriously.
Right.
And so there's,
I guess, from
some hope that the decision will say that C2, the thing with no requirement of an actual factual finding, that they might say that's an infringement.
Yeah, from your perspective, I imagine it's better that they brought it up a number of times rather than they didn't talk about it at all.
At least, exactly. At least they're paying attention to me, as the 15-year-old girl said.